All right. So you want to come back in the first week in May for a plea deadline date, counsel?
Thank you, Judge.
All right, Ms. Ferguson, on Saldana, can I have a plea deadline date first week in May? May 6th? You said the 6th?
Yes.
All right. So we'll be back on May 6th. On May 6th, you need to let the court know whether or not you're accepting the state's offer. Do you understand?
Yes, ma'am.
All right. We will see you back then.
Your Honor, just for clarification, I was explaining to Mr. Saldana the court's practice with respect to plea deadline dates. If the court could go into detail with that for Mr. Saldana.
Sure. All right. Mr. Saldana, always make sure that the state has given all of the discovery to defense counsel. So that's been done in this case. And then the next step in our process here in the 187 District Court is I require that the state tender an offer. Once the state has tendered an offer to you, I give you a chance to think over it and make a decision on whether or not you're going to accept it. So when we come back on the 6th, you need to let the court know whether or not you're going to accept the state's offer. If you choose not to accept it, then the next step will be both the defense and the state will let me know how long they think your jury trial will last. And I will give you a jury trial setting, and the court will not consider any plea bargain agreements without good cause. You understand?
Yes, ma'am. Can I speak now?
Sure.
Yeah, this on the record. This is my first time speaking to my attorney. He hasn't done nothing in my defense.
All right, let me explain something to you.
I understand.
Let me explain something to you. When your attorney gets appointed, that's when they get appointed, right?
Yes, ma'am.
So your attorney has been appointed to represent you. Your attorney is here to speak to you. Your attorney will speak to you as long as you want him to speak to you. Do you understand?
Yes, ma'am.
All right.
So what if there's nothing being spoken though?
Oh, just Mr. Sandoval.
He's kind of busy. He has a lot of cases
Mr.
right now.
Sandoval,
Yes, Judge.
could you sit in the box and speak with your client some more? He appears to wish to have more communication with you.
I'd be happy to, Your Honor. Mr. Saldana is making reference to, I'm on a call in the 186 Impact Court. So that's why I was letting him know that we did not have time to go over everything this morning, but that I would be visiting with him.
All right, let's do this. You're on call for jury trial, right?
In the 186 Impact Court.
All right. Do you know when they will let you know that you're off the hook?
Well, I'm hoping soon, Your Honor, because I actually have unavailability notice on file. But
Okay, let me ask you this. Are you able to come back tomorrow?
yes, Judge.
All right. So Deputy Laura, can you have Mr. Saldana and Norma put Mr. Saldana on the docket for tomorrow? So we'll see you back tomorrow.
And I apologize, Judge, but I just haven't had no time to prep, and this is the person I sent discovery, you know what I mean? So I don't know what's going on.
Oh, there's no need to, here's the thing.
Case involves a minor.
No, stop the phone, stop the phone. I'm hanging up. Let me just tell you why. The reason why I'm hanging up is because whatever the parties think the facts of your case are, there's only a certain circumstance where I will hear what the facts are about before jury trial. And that has not been presented to the court. So I'm not to hear about any facts of this case, usually, unless there's a plea or there's a jury trial that's happening. But you coming to me and saying, let me tell you about my...
All right, pause right here. This is a plea deadline. That means this is the last real off-ramp before things get serious. Once that date passes, the court is basically saying decision time deal, or jury, if you were in this defendant's shoes, would you gamble on trial or take the offer?
Case. If you want to do that,
I
no,
apologize.
that's okay. If you want to do that, you can do it in the form of a bench trial, if everybody agrees to a bench trial. So you're going to come back tomorrow and your attorney will be able to show you the discovery. You understand? Anything else?
Please, so Judge, I do have other settings tomorrow, so I may be a little tied up.
Oh, that's fine.
In the morning and then settings, but I will visit again with Mr. Saldana tomorrow.
Oh, no. You can do your other settings first and state, we're going to be in trial here. So if you will just make sure your file is brought down here, and we'll make sure that he gets a chance to see what's in the state's file.
Thank you, Judge.
All right. Is there anything else? All right. Court is calling 2023 CR 4712, State of Texas versus Nancy Zavala. Can I have parties announced for the record for the state?
Case here, Your Honor.
Defense?
For the defense.
And are you Ms. Zavala? Thank you so much for dressing appropriately for court. I appreciate that. All right. Counsel, have you received all the discovery? Did you review it with your client?
I believe so, Your Honor.
Court will find that the state is in compliance with discovery. Mrs. Zavala, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you weigh the reading of the indictment?
Yes,
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of theft under $2,500 enhanced? That is a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
yes, she has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I believe so, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so, Judge.
Ms. Zavala, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 90 days in the Bexar County Jail under 1244. The state will take in consideration night mag number 691192 and 709885. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
That is the plea, Your Honor.
State, is that the plea?
It is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
Say again, Your Honor?
Have there been any such motions?
No, there is.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the plea?
Yes, Your Honor. City Exhibit number 1 with office attachments.
No objection.
Showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept in the evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing, counsel?
Not at this time, Your Honor. We request from the court that Ms. Zavala be allowed some time to get her affairs in order before she presents herself for custody.
All right, so Ms. Zavala, the person who's listed in here is the person you were in the store with. Is that the gentleman that's with you or someone else?
No, Your Honor.
All right, so why are you committing these thefts? What's your problem? What's going on in your life? Is it a drug issue? Is it a...
I just made a mistake. I'm here to accept my responsibility.
No,
I'm
but
learning on-
see, here's the problem.
Yes, sir.
I know you're here to accept your responsibility, but you're going to get to the point, if you continue on this vein, because these are state jail felonies, you're going to get to the point where you're going to end up with maybe a state jail felony.
This moment right here is tense. The defendant feels unheard, and that's a dangerous feeling in court. But legally speaking, appointed counsel doesn't mean constant conversation. It means representation. When it counts, still perception matters. How many of you think this breakdown in communication could have been avoided?
As a habitual, which you'd be looking at hefty prison time. There comes a point in time where these theft cases, even though they're state jail felonies, they can be enhanced in Texas. So I'm trying to figure out, one, what are your issues? Why do you keep committing these thefts? If it's some kind of behavior that maybe can be changed, fine. If it's a drug issue, fine. If it's a mental health issue, fine. Maybe we can do something with it. But this whole thing where you're coming in, I just want to accept my time and be done with it. At some point, your time is going to be real time. So I'm trying to figure out, and I know all time is real time, but I'm trying to figure out what your problem is.
Well, Your Honor, if I may.
Yes.
She has had her issues in the past. I have spoken to her at length.
What are these issues?
That she didn't want. She has impulse control problems. The part of her problem is going into a store and wanting food or what have you, and not having the wherewithal to go out and earn the money and get the food and consume that item. She has had impulse control problems, but I've talked to her at length, and I believe that she understands the gravity of the situation. And in addition, as the court has informed her, that she may end up facing significant time behind bars if she continues down this vein. And she has told me that she has realized the error of her ways and that she has actually, in her mind, reformed.
All right. So has she reformed in the past? And then, because I think, I could be wrong, and if I'm wrong, you can correct me. Sometimes people realize their issues the third, the fourth, the fifth, the sixth time. I understand that. But you have prior convictions for this. State, did the defense confer with you about having this called back for sentencing?
They asked, I said I defer to the court whether be allowed back. I did mention to the defense counsel that we would be asking that the full range of punishment would be on the table if the defendant did not show for sentencing.
All right.
Yeah, that was informed, and I was aware of that. That if the court does grant this, that the court has in the past.
All right, Ms. Zavala, is there a reason why you can't go into custody today?
Well, getting my stuff like arranged, like with my boyfriend, the rent, like let them know that I'm not gonna be paying the rent no more, like at the moment. Just, and then with my kids, with my son, I just had a grandbaby, and I just want to meet her. I haven't met her, and I want to meet her. Yeah, and that's just the truth about honestly.
Okay. So how old is this grandchild?
She was born February 13th.
Why haven't you met her?
Because they were out of town. They were out of town, so they barely came back. Or was it last week? Was it last week?
Yeah.
So your grandchild has been out of town for 5 months?
Yes, yeah. But they've been busy. They've been going back and forth to Mexico to Piedras Negras. And so they've been with his wife, my son's wife. He's from over there, so they've been going back and forth. And so he said that if I can meet her this Sunday coming up at church, at the First United Pentecostal Church on Utopia Street.
All right, we're coming back on July 17th.
Oh, yes, Your Honor.
Ms. Ferguson, can you give them a reset form for July 17th? And you understand a part of your plea bargain agreement, if you do not present yourself on July 17th, then you're subject to the full range of punishment. Do you understand?
Yes, Your Honor.
And that full range of punishment is up to 2 years in the state jail facility. Do you understand?
Yes, Your Honor.
All right, we'll see you back on the 17th. You're welcome. Ms. Ferguson will give you the reset form, then you're excused.
Thank you.
Court is calling.
And here comes the hard stop from the judge. Courts do not hear case facts casually. No storytelling, no venting facts come out in a plea or at trial. Nowhere else. This is courtroom structure colliding with raw frustration, and neither side is backing down.
2023 CR 9851, State of Texas versus Joe Anthony Vasquez. Do I have parties announced for the record for the state?
Second for the state, Your Honor.
Defense?
Robert here, Your Honor, for defendant Joe Anthony Vasquez, and we're ready.
All right. And are you Joe Anthony Vasquez?
Yes, Your Honor.
Counsel, have you received all the discovery? Did you review that with your client?
We did, Judge.
Court will find that the state is in compliance with discovery. Mr. Vasquez, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Are you proceeding on the enhancement allegation?
Yes, Your Honor.
All right. Mr. Vasquez, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of assault family second offense? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
All right, off the record for a moment, please. All right, we're going to go back on the record. I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge, we do.
All right, it's my understanding that off the record, there was a discussion and states you're proceeding on paragraph 2 of the enhancement. Is that correct?
Yes, Your Honor.
All right. So I'm going to show you what's entitled assault family second. I'm sorry, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
All right. Did you understand you're charged with assault family second offense? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the state is able to prove up the enhancement allegation, then your range of punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to keep those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe that he is, and he was, Judge.
Mr. Vasquez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, you agree that you've been previously convicted of 1 or more felonies for enhancement. Punishments be assessed at 6 years in the prison. There are no applications. The state is taking in consideration 2023 CR 9852. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Brittany Jimenez. All right, off the record. So parties know, unless Brittany Jimenez is here to state that she wants to have contact with him, the court is not inclined to follow that portion of the agreement. So is that going to be a deal breaker?
I don't think it'd be a deal breaker, Judge. Just to inform the court, she did sign a affidavit of non-prosecution in these matters.
All right, if y'all want to remove that in the initial.
Absolutely, Judge. So,
What does that mean?
you can't contact Brittany while you're in.
Oh,
I just put NCO, Judge. That'd be okay with you?
I'm sorry?
NCO? Oh,
Yes,
contact.
that's fine.
Yeah.
Thank you. All right, and there's to be no contact with Brittany Jimenez. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
And did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea?
Yes, Your Honor.
This is a critical legal moment. The court finds sufficient evidence and enters a guilty finding without live testimony. That's the power of stipulations. Once you waive your rights, hear the case moves fast. Would you ever feel comfortable pleading guilty without hearing witnesses testify?
Defense, is that the plea?
That is, Judge.
State, is that the plea?
Yes, Your Honor.
I'm going to show you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Judge.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
And to the enhancement paragraph, paragraph 2, how do you plead? True or not true?
Excuse me?
The enhancement paragraph that's in the indictment, how do you plead to that? True or not true?
True.
Right. State any evidence to support the defendant's plea.
Yes, Your Honor. State offers states 1 and attachments.
Defense is reviewed, Judge. We have no objections.
Mr. Vasquez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
Yes.
Did you understand, again, that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty, and the court will find the enhancement true based upon your plea of true. Are you proceeding with sentencing?
We're ready for sentencing. Your Honor.
Anything you wish to say on behalf of your client?
No, Judge.
All right, the court will follow your agreement, find you guilty, find the enhancement true. That's paragraph 2. Sentence you to 6 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Brittany Jimenez. Take in consideration 2023 CR 9852. Is there anything else with regards to sentencing?
Nothing further from the state, Your Honor.
Nothing further for defense, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Obviously, you have anger issues. You're one of those people who, you know, I told the last gentleman he shouldn't drink alcohol.
Yeah.
You shouldn't be in a relationship.
Yeah, I know.
Yeah, I mean, you say you know.
Sides to it, though.
Well, I mean, the problem is you say there's 2 sides to every story, but you can't go to somebody's house, break in a window, and then having them get in the car with you and threatening to damage the car with a crowbar if they do not. And you have other assault family cases. And I don't know why, but, well, I do know why. I know that, well, I should say I know the different reasons why people stay in relationships that are abusive. But the fact that this person even continues to want to have contact with you, not happening. You need to move on. And you need to take care of your anger issues. So this is what you need to do. When you go to prison, do not be thinking about women. Do not be thinking about a relationship. You need to sit down and ask yourself how you got in the position you're in. And then when you're released from prison, because at some point you're going to be released, go get an orchid. They sell them throughout the year. That orchid is going to come with blooms on it. Once the bloom falls off and you're able to get that orchid to rebloom, you may be ready for a relationship. You understand?
All right.
And if you come back for this, you know what your minimum is going to be in a case? 25 years. That's where you're going to be starting at, because you're going to be a habitual. You understand?
Yes, Your Honor.
All right, good luck to you.
All right, thank you.
This isn't just sentencing, it's a warning the judge is laying out the future consequences plain and clear. In Texas, repeated low-level theft can snowball into serious prison time. This is the court trying to interrupt a pattern before it becomes permanent. That orchid analogy, brutal but intentional. This is the judge saying fix yourself before you hurt someone again. Courtrooms don't usually get this personal, which tells you just how serious the situation is. Do you think tough love like this actually works, or does it come too late?